I forgot to add myself to the stage, but there I am. Well, good evening. Hello, my friends. How are you doing? Hey, Mark, how are you? Go. Good to see you. Hey, Jelly Snacked Cara, nice to see you. Hey there, Alps. How are you doing, my sweet Insolent Violet? So glad you're here. Hello, Wes. Mr. Level, nice to see you. And Joe, thank you so much for joining. I do appreciate it so very, very much. And I'm trying to move Mr. Chalupa's little hiney over a little bit. You're a honeybee, Mark. Oh, I love that. That's so sweet. And Salsa is looking very dejected, hanging her little head over on the side of the bed. I think she's upset because I closed the door and she was like wanting to sneak out and, do mischief. And, I just kind of curtailed that. How are you guys doing? How is your week going? Is it a good week? I think it's a pretty interesting week. I've actually been in a lot of pain this past weekend. I had an exceptionally difficult weekend, and I don't have my spinal stimulator on right now because they're wanting to reset everything. So I'm without that. And I'm kind of glad because over the weekend, whatever program it was on, it's like it was just making everything worse. And no one needs more pain, right? We're looking for less pain. None of us who are dealing with chronic pain are like, yeah, give me more. Nope. That's not what we're doing. Well, I have two documents that I'm going to be sharing with you. One is the mediation report, which is not the one that you guys are, really curious about, but I'm going to show it to you anyway. So let me go ahead and do that. Let's see, share screen, and is it going to be, which one is it? Hang on. I think it's this one. Oh, crap. And why will it not let me do that right now? I'm going to need to make something smaller. Okay, give me just a second. Because then I have problems when I'm trying to share stuff. I have to bring it over to different sides of things. Okay, now where did you go? Now I can't find my actual. There you are. You are. So are we at the mediation report? Okay, I'm just trying to make sure that I'm on the right thing. Okay. So the mediation report just lets us know that, hey, look, these are the parties, involved, blah, blah, blah. And it basically lets us know that the conference was continued, and this happened on June 6th of this year. So like I said, this is not the one that you're actually interested in, but I did want to share this with you. Hey, Curious, how are you? Hello there. Hey, Heather, how are you, my dear? Hope you're doing very well. The one you actually are interested in is this new order, which was the ruling on the motion to dismiss. Now, the motion to dismiss originally happened last October. And this in general is something that, that lawyers will do. They'll look to see, like, can we just get this dismissed? Smile, grin, nudge, nudge, think no more, that kind of thing. Like, surely we can just settle this right now. We'll just dismiss it all. And the judge is like, no. Yeah. And so we're basically going to be going over as to why the judge said, good try, but yeah, that's not going to happen. So let me stop that, close this one out, and try to get the other things that I'm sharing to you in the right way. Okay, so All right, and I am going to take my little self off of here so that you can just see all of it. And you can see this is the SEC, which is the plaintiff. The defendants are, Ash, OnPassive LLC, and his wife, Asmahan. And I will let me get a sip of something, and let me bring my water jug over here. And I have a bit of cherry Coke. I love cherry Coke. I fell down today on my butt. I'm trying to sit down in my chair after I got something. I just went flying every which way. That was a lot of fun. But I was wearing a pair of cute pants. Does that count? Does that count? I was wearing my very cute Beetlejuice pants. All righty. So here we go. Defendants, Mr. Ashraf Mufara and Mrs. Asmahan Mufara and their company OnPassive LLC moved to dismiss the amended complaint filed by plaintiff, the Securities Exchange Commission. Defendants contend that the amended complaint is a shotgun pleading. Now, the amended complaint was filed November 6th of last year. The original complaint was filed on August 11th of last year. Just kind of like get that all together. So they contend the amended complaint is a shotgun pleading, and that counts 2, 3, and 5 failed to state a claim. The SEC opposes the motion. Upon consideration for the reasons outlined below, the court denies the motion. So the court is like, good try, but yeah, no, we're not doing that. Hang on a second. My plug for my laptop came undone, and I don't want to run out of juice in the middle of this. So now I've got to lean on over. Hang on a minute, guys. Oh, all right. Now that we got that back in, that's right. The court said nay. That we're not falling for this kind of BS. Okay. Well, I meant to go get my mouse and I didn't. So, well, we'll just deal with it. Mr. and Mrs. Mufara are the co-owners and co-founders of OnPassive, an Orlando, Florida-based company. Now, remember, this is OnPassive LLC. There are several iterations of OnPassive, like depending on where it is in the world, which one it is, and who's in control of what. But anyway, we're going with the one that, has been based out of Florida that is now registered in Delaware. I knew I'd get that word out of my mouth. That purports to be developing a suite of computer applications using artificial intelligence, AI, that will seamlessly interface with one another in an ecosystem similar to applications offered by established, well-known multinational technology companies. To date, OnPassive has not fully developed or made commercially available a suite of online computer applications. Mr. Mufara has been the Chief Executive Officer, CEO of OnPassive since its November 19th, 2018 formation, and as such has wholly controlled all the company's operations and had ultimate authority over its activities. Again, OnPassive LLC. There are the other ones as well, but we are speaking about OnPassive LLC. I'm just trying to make that really, really clear. Both Mr. and Mrs. Mufara have benefited financially from OnPassive's activities. As OnPassive CEO, Mr. Mufara solicited investors for the company using email and live webinars that were usually produced from his Orlando home. No, I'm having a phone. Is Orlando home? Oh, there it is. The investment program that he employed is the focus of the SEC's claims. The SEC alleges that Mr. Mafara and OnPassive have engaged in misconduct related to the investment program every year from 2018 to 2023. Okay, so now we're going back to 2018. Let me see if I can get all of it. Oh. You know, guys, I am going to go run and get my mouse because this will make it easier for me than trying to just use the up and down arrow. I apologize. This is going to drive me nuts. Give me just a second. Let me go get that. And Salsa, you're in my way. Ah! And then the laptop went flying. Give me just a moment. Sorry, guys. I should have brought that with me, but I didn't. Hoping to be able to get through, but I'm not. But I'll fix it. Be right back. Already back in the same room with you. So you didn't even have to like start singing songs or anything because I'm back. And little Miss Salsa, boy, did she try to escape. Opening. I can go and perform mischief. And then my laptop fell over. So you probably heard a big ka-clunk because that's what that was. Let me reconfigure myself. Loving the life update. Yes, as I run into another room fast, grab something, come back. Ugh. All right, now I have my infamous heating pad on. It's feeling extra good today because me falling on my butt, on my sliding off my chair earlier, yeah, that kind of bothered my lower back a bit. Oh my gosh. Oh my gosh, Jelly, you just slayed me. Mike Ellis reading this in a really good place. Oh, my friend, did I need that? That was hilarious. Yeah, it's like, you know, they can be up to their necks in hot lava. We're in a really good place. I can just feel it. Things are really moving. All right. So here we are. Now I can actually move this up here a little bit more easily. All right. Beginning July 2018, Mr. Mafara recruited investors for OnPassive. He used a non-public website, which he called the back office, to facilitate and track his recruitment efforts. He referred to investors who registered through the back office as founders. An investor who wanted to be a founder was asked to pay a fee of $97. Generally, Mr. Mafara encouraged, okay, Salsa, what are you trying to do, child? Encouraged each investor to purchase multiple $97 positions in OnPassive's investment program to increase the investor's potential for income. Isn't that nice? He was just looking out for them. He distinguished between founders who paid the $97 fee and those who had not yet paid, describing the latter as holding free positions in the program. Mr. Mafara stated that he could remove any founder holding a free position at any time before OnPassive's suite of applications launched to consumers. He further stated that he would eliminate all free positions by the suite's launch so that only paying founders would be eligible to maintain their positions. Mr. Mufara claimed that founders would share in profits that would come from monthly subscription fees paid by the suite's users. And who's going to buy this stuff? Oh, yeah, that'd be the people who joined. Okay. He also claimed that founders could receive as a commission a portion of the fees paid by those who invested in the OnPassive after them. To that end, he purportedly kept track of the order in which the founders registered. Beginning on July 17th, 2018, and continuing through at least October 2018, Mr. Mufara composed and sent or directed others to send hundreds of emails to potential investors. Each email stated that Mr. Mufara would send an update when the program launched, which would occur in about 1 month from the date of the email. Mr. Mufara made this statement even though he and Mrs. Mufara were the only two persons involved with any aspect of OnPassive's operations, and neither had any expertise to develop a suite of computer applications using AI. In September 2018, Mr. Mufara retained an information technology IT outsourcing firm for OnPassive. At least during the first 2 years, this IT firm and the in-house IT personnel that Mr. Mufara subsequently hired focused on developing the back office rather than the applications that OnPassive was purportedly launching. At least up through August 2020, defendants hired personnel and expended resources chiefly to develop OnPassive's back office website used for recruiting new investors, tracking placement in OnPassive's investment program, and marketing the OnPassive income opportunity. Curious, this is so tasty. I'm so glad you just like the flavor of it. On September 25th, 2018, Mr. Mufara participated in a live webinar for OnPassive, during which he stated that OnPassive was operating legally and said, "We're closer to launch. We're in the second half, maybe the last third, and you do the math. I don't have a date. I'm going to touch up on that respectively. It's realistic to launch in the next 30 days? Very much possible. I would say, okay. Oh my gosh. I really wish I could do this in Ash's voice, but you know what? I'm sorry. I just cannot speak in that kind of a convoluted tone in which we all know what it sounds like. And it's always just so weird with odd pauses and then, inserting okay very often. It's just, I find it so cringy. Is it just me, or do you guys find it cringy too? Because I'm always like, ugh. It's always so awkward when he's speaking because he never has like, oh, gee, I don't know, some notes to go by. Hey, Nancy, how are you, sweetheart? Okay. Also, during this webinar, Mr. Mufara shared a payment grid entitled All Monthly Residuals for Life, which showed that a founder could receive up to $2,032,614 per month for life based on the assumption that 10 levels of recruits comprising 88,573 commission-generating positions would invest in OnPassive after the founder. So that would be each founder would need that many people signing up underneath them. That sounds really probable, doesn't it? Excuse me. Excuse me. Pardon me. In addition to stating that the grid showed how it was possible for founders to receive over $2 million per month if up to 10 tiers under them were fully populated, Mr. Mufara suggested during the webinar that $30 million per month was feasible if more than 10 rows were populated. Now, you guys may remember that I showed you the email between Michael AIM, automatic internet millionaire Williams, and Ash, and how Ash had approved of like Michael's calculations of over $2 million. Do you guys remember that? Because that's where that stuff's coming from. A week later, during another live webinar, Mr. Mufara said, "We are definitely closer to the launch than we announced this concept, let's say, in the past. So we're clearly in the probable..." I'm sorry. This just is so gobbledygook. So we're clearly in the probably last third or quarter, maybe. So basically he's saying, I don't know where the hell we are in this, but yeah, sure, we're close to launch. That's what I'm reading. Sorry, had to put my spin on this nonsense. The payment grid and recordings of these webinars were posted to the back office after the webinars. And when I'm saying this nonsense, what I'm referring to is their quoting of Ash. Not this document is not nonsense. This document is a factual document, but it's like how they're quoting what he said. But then we move into 2019. Hello, Kim. How are you doing, my dear? Hope you're having a good one. In early 2019, pre-existing and independently operated third-party websites aimed at reviewing multi-level marketing MLM programs posted multiple negative reviews of OnPassive and Mr. Mufara. On January 7th, 2019, a website posted a review stating, "There's inherently nothing of particular interest with OnPassive. It's literally nothing more than a pyramid scheme launched by a serial scammer." On February 28th of 2019, another website posted a review stating, "OnPassive is a scam, and here is our main reason why. No retail products offered. Sure, the company offers a marketing platform that you can gain access to, but only as an MLM affiliate member." Third, fourth, and fifth alterations in original. Mr. Mufara initially responded to the negative reviews by advising investors to ignore the haters. Isn't that what all companies say? I mean, I was in a meeting today and they're just talking about all the haters. They're just like, oh my gosh, our competition, they're just the haters. I always find that so humorous. In April 2019, Mr. Mufara reviewed, edited, and authorized for posting to the back office the following information about OnPassive's founder positions. When you accept an early founder position, you've placed in OnPassive's top leadership. This is the top 1% of the leaders in the company, and the teams under these leaders are built literally hands-free. This is done through company-wide marketing campaigns using 4 or 5 of the world's best, largest data exchange companies to run the campaigns. These campaigns are fed using proprietary databases developed and owned by OnPassive that consist of leads incredibly targeted to specific industries. Before the public launch, the primary purpose of the existing founders and the company campaigns are to invite other founders. The founder positions are ranked according to 1, the date the position was acquired, and 2, the number of paid founders they have personally sponsored. Also in April of 2019, Mr. Mufara reviewed, edited, and authorized for posting to the back office the statements, "We are fully legal worldwide. We are fully compliant worldwide. And we will not be shut down by a government. They will use our products." Mr. Mufara repeated these statements in December 2021. On April 25th of 2019, Mr. Mufara participated in a live webinar during which he said, "In June, we will have a kickstart party in Orlando, last weekend of June. Celebrate launch or opening, whether it's already open or getting tested, just ready to launch. A recording of this webinar was posted to the back office. During an August 2019 webinar, oh my gosh, if I could actually talk sometimes, Mr. Mufara stated that OnPassive was illegal in every company in which it operated, or there would be workarounds to make it legal. Further, between August 2019 and at least December of 2021, Mr. Mufara increased the number of applications that OnPassive would purportedly launch. The number began as approximately 30, but grew to over 50. In November of 2019, because negative reviews persisted about OnPassive on MLM review websites, Mr. Mufara allegedly approved the creation of Counterfeit and intentionally misleading websites that mimicked the names and appearances of the two websites that had posted the above-mentioned negative reviews. The domain names of the counterfeit sites were nearly identical to those of the existing review websites. One counterfeit site's name differed from its existing site's name only in the counterfeit site's name ended in .us, while the existing site's name ended in .com. The other counterfeit site's name differed from its existing site's name only in the counterfeit site's name used a singular form, while the existing site's name used a plural form. In addition, each counterfeit site incorporated into its logo the name of the existing site that it was allegedly copying. Mr. Mufara personally registered the counterfeit sites, but paid to have the sites registered the name of a domain proxy, which the SEC alleges allowed him to conceal his and OnPassive's involvement with the sites and to deceive investors into thinking that the reviews posted on the sites were objectively made by independent third parties. Hey, Takara, you just got here? No, it has not been thrown out. Hardly. Nancy says, very hilarious yet disturbing with all this info. Why do these people cling on to such nonsense? You know, I really wish I could tell you. I only can think of cognitive dissonance. But at some point, it's like, don't you just have to like snap to reality? Had to get a little sippy poo there. Because this document is over 30 pages, so it's going to take me a while to get through it. Okay. Domain proxy, which the SEC allows us to conceal the deceived investors. Okay. Mr. Mufara used the counterfeit sites to publish positive reviews of OnPassive and himself. In addition, OnPassive employees posted on the counterfeit sites reviews of other programs and general advice about MLM programs, topics that existing MLM review websites typically covered. According to the SEC, OnPassive employees proposed that they would use the two counterfeit sites as third-party sites, write exclusive reviews on their own brand, just like a third person's writing, and use both counterfeit websites to influence the people, with the first target assigned being to knock down the existing sites from the search results. Mr. Level says, because founders are in a real tough positions right now and see no alternatives, they are really hoping and praying OnPassive works out because all the founders are scared. Yeah, they are all scared. And yeah, that is true. You think about what happens when OnPassive shuts down. What is their next alternative? Well, they have held on to something far too long. That's the thing. They have held on to smoke and mirrors. They have held on to false promises. And there's nothing. They have nothing. They never had anything. And they're going to have to somehow reach that conclusion. And Kira said, and sunk cost fallacy. Hello, Baron. How are you doing? Um, okay. Mr. Mafara allegedly approved this proposal. The About section of one of the counterfeit sites stated, our only objective is to educate users who are searching for companies, including MLM, primary target industry. We summarize a company's overall status and reputation in the market. These reviews could help any user to identify and decide whether to approach a company or not for any business or professional reasons. On November 30th, 2019, a counterfeit site posted a review that recommended being part of OnPassive and stated that OnPassive was scam-free, fully legit and compliant, and had a global presence in more than 100 countries. Overall, OnPassive personnel wrote and posted 7 positive reviews on one counterfeit site between November 2019 and March 2020, and 6 positive reviews on the other counterfeit site between December 2019 and March 2020. Then we move to the year 2020. In February 2020, Mr. Mafara announced in a webinar posted to the back office that the target audience for OnPassive was being expanded to include anyone interested in using AI applications. He also reviewed and approved for posting in the back office an allegedly false marketing message from a founder with realistic, conservative, and worst case scenarios. The message projected that founders would earn over $32 million through OnPassive's investment program and touted the purported income benefits of buying multiple positions in the program. On February 16th of 2020, a counterfeit site posted a review stating, why do I believe that OnPassive is responsible for taking my business goals to heights which I never thought I could? With all of these advantages in front of my eyes, I couldn't stay blind and not plunge into becoming a member of OnPassive. In March, June, August, and October of 2020, Mr. Mafara made more statements about OnPassive during webinars posted to the back office. On March 26, 2020, he stated that OnPassive was going to launch and that everything was looking good for 2020. On June 11th, 2020, he focused on the positive online reviews of OnPassive from the counterfeit sites and said that someone who saw them was more likely to register for OnPassive and pay the $97 fee to become a founder. On August 6, 2020, he reiterated that OnPassive was scheduled to and set to launch in 2020. If we need more time, he said, we will let you know right now. We don't feel there's any necessary time to launch. We have plenty of time to complete the remaining portion in 2020. The 2020 launch date from the August 2020 webinar was repeated in 6 emails, which were drafted by members of OnPassive's leadership and transmitted via OnPassive's official email address to prospective and existing investors on various dates from August 31st through October 31st, 2020. On October 15th, 2020, Mr. Mafara stated that all that was left was realistically a few weeks of testing. He added, if now we are considered in pre-launch, how much more launch you want? Like, okay, just the ribbon cutting? It will happen. It's a done deal in my mind. That's why I operate as we already have a billion-dollar business in every country on the planet. Also in August 2020, OnPassive officially announced that its suite would include 30 software applications that would work together in an ecosystem. However, By the time of this announcement, OnPassive had not begun development of most of the 30 applications that were to comprise the ecosystem. Indeed, it had completed only 2 comparatively simple software applications, an Internet Protocol address IP tracker, and a uniform resource locator URL shortener, equivalents of which were already readily available to the public online for free. Because OnPassive's purported plan was to launch all applications simultaneously as an ecosystem, OnPassive had not launched these 2 applications yet. 2021. By December 2021, Mr. Mafara had allegedly changed the participation requirements for OnPassive's investment program in 3 ways. First, the monthly subscription fees would no longer be in the range of $25 to $900. The fees would be substantially higher than those amounts, but the new pricing was unspecified. Second, a founder's $97 initial payment would no longer be deemed to cover the monthly subscription fees during the first year following the commercial rollout of OnPassive's suite of applications. Instead, founders would have to pay a monthly subscription fee. Third, every investor would have to check a box on OnPassive's website electing to be a reseller. There was no added cost for electing to be a reseller, and electing to be a reseller did not obligate the electing person to do anything. Consistent with this requirement, a document posted to the back office from December 2021 to August 2022 stated that every founder would elect to become a reseller. Another document posted to the back office from December 2021 to August 2022 discussed how a participant on OnPassive's investment program could profit by recruiting additional participants to the program. The document asserted that a participant could have an infinite team of downstream recruits from which the participant would draw commissions and earn unlimited residual income for life. The document also stated that a participant could earn thousands and even millions of dollars. Mr. Mafara reviewed and edited the document and authorized its publication through the back office. Then we move on to 2022. On June 22nd, 2022, OnPassive stopped accepting founder registrations. However, it continued to accept $97 payments from the founders holding free positions as of that date, resulting in the payment of tens of millions of dollars in founders' fees subsequent to June 22nd, 2022. In November 2022, OnPassive made available to the general public 4 applications, including the IP tracker and URL shortener, all free of charge. Since then, OnPassive has offered 2 additional applications to the general public free of charge. As of June 30th, 2023, the remainder of the applications in OnPassive's suite had yet to be released, and the commercial rollout of the suite had yet to occur. Now we move to 2023. As of March 2023, OnPassive had received more than $108 million from more than 800,000 investors located in the United States and abroad who brought more than 1.12 million founder positions. That's just easier for me to say. The SEC describes these millions of dollars as illicit proceeds that defendants received as a result of their misconduct. As of June 30th, 2023, OnPassive had not yet launched any product for a fee or paid any commissions to investors. Procedural history. Gotta get a sip. Hey, Beth, welcome. Okay. On August 11th, 2023, the SEC filed the initial complaint in this case, bringing 5 counts. The SEC brought 3 counts against both Mr. Mufara and OnPassive, unregistered offers and sales of securities in violation of this particular, I'm not going to read out what this number is, fraud in violation of this other listing, and in fraud in connection with the purchase of or sale of securities. And then there's another violation of what that is, what it is like they're stating. The SEC brought 1 count against Mr. Mufara separately from OnPassive violation as a control person. The SEC also brought a count against Mrs. Mufara as a relief defendant for unjust enrichment pursuant. The SEC sought 4 main forms of relief: a permanent injunction restraining Mr. Mufara and OnPassive from violating federal securities laws and from participating in MLM programs, disgorgement of defendants' ill-gotten gains, along with prejudgment interest, civil money penalties, and a judgment prohibiting Mr. Mufara from serving as the officer or director of certain business entities. Defendants moved to dismiss the initial complaint with prejudice, arguing that it was a shotgun pleading and that counts 2, 3, and 5 failed to state a claim. In response, the SEC amended its complaint. The amended complaint contains the same counts and requests the same relief as the initial complaint. Defendants now moved to dismiss the amended complaint, making substantially the same arguments they made in their motion to dismiss the initial complaint. Applicable standards. Federal Rule of Civil Procedure requires a complaint to contain a short and plain statement of a claim showing that the plaintiff is entitled to relief. And that requires the plaintiff to state its claims in numbered paragraphs, each limited as far as practicable to a single set of circumstances. To promote clarity, Rule 10b also requires the plaintiff to state each claim founded on a separate transaction or occurrence in a separate count. Complaints that violate either Rule 8a2 or Rule 10b or both are often disparagingly referred to as shotgun pleadings. Shotgun pleadings fail to give the defendants adequate notice of the claims against them and the grounds upon which each claim rests. One type of shotgun pleading is a complaint that is replete with conclusory, vague, and immaterial facts not obviously connected to any particular cause of action. A court may dismiss a complaint as a shotgun pleading only where it is virtually impossible to know which allegations of fact are intended to support which claims for relief. In deciding a motion to dismiss for failure to state a claim, a court accepts the allegations in the complaint as true and construes them in the light most favorable to the plaintiff. To survive a motion to dismiss, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. A claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for misconduct alleged. Detailed factual allegations are generally not required, but a pleading that offers labels and conclusions, or a formalistic recitation of the elements of cause of action will not do. Generally, when analyzing a motion to dismiss for failure to state a claim, a court considers only the 4 corners of the complaint. However, a document outside the 4 corners of the complaint may be considered if it is central to the plaintiff's claims and is undisputed in terms of authenticity. A claim sounding in fraud must state with particularity the circumstances constituting the fraud. To meet this particularity requirement, the claim must set forth 1, the precise statements, documents, or misrepresentations made. 2, the time, place, and person responsible for the statement. 3, the content and manner in which these statements misled the plaintiff, and 4, what the defendants gained by the alleged fraud. In other words, the claim must provide the who, what, when, where, and how of the alleged fraudulent activities. However, malice, intent, knowledge, and other conditions of a person's mind may be alleged generally. Analysis. Defendants argue that the amended complaint is a shotgun pleading and that counts 2, 3, and 5 fail to state a claim. The court first addresses the shotgun pleading argument, then examines counts 2 and 3 together, and finally discusses count 5. Yep, I remember the force matrix. 1. Shotgun pleading. Defendants maintain that the amended complaint is a shotgun pleading because it is replete with conclusory, vague, and immaterial facts not obviously connected to any particular case. Defendants reason that every count but count 1 incorporates virtually all of the amended complaint's general factual allegations and then simply states the elements of the cause of action. Further, in defendant's view, although the amended complaint generally alleges the defendant's statements described in paragraph 59, 61, and 62 were false or misleading, it does not identify those statements as basis for counts 2 and 3. Defendants claim that they therefore do not know whether those statements are intended to support those counts. The SEC responds that incorporating the same factual allegations in multiple counts is proper here due to the scope of the fraudulent scheme. The SEC further contends that for 2 reasons, the amended complaint affords defendants more than sufficient notice that the statements described in paragraphs 59, 61, and 62 are intended to support counts 2 and 3. First, those counts refer to paragraph 64 and 68 as bases, and paragraph 64 and 68 refer to the statements in paragraphs 59, 61, and 62. Second, the counts incorporate by reference paragraphs 59, 61, and 62. The court agrees with the SEC that the amended complaint is not replete with vague, conclusory, or immaterial facts which are extraneous to its cause of action or which make it difficult to decipher the base of each claim. The amended complaint does not make it virtually impossible for each defendant to know which allegations of fact are intended to support which claim for relief. Holding that even though the complaint was certainly long and was not a paragon of clarity, it was not a shotgun pleading because its form did not prevent the district court or defendants from understanding the basis of the claims. The problem with a shotgun pleading is that each subsequent count is replete with irrelevant factual allegations and legal conclusions. Here, the complaint simply contains general factual allegations that are relevant to almost all of the SEC's claims. The court also agrees with the SEC that the amended complaint adequately informed defendants that the statements described in paragraphs 59, 61, and 62 are intended to support counts 2 and 3. Paragraph 59 states that Mr. Mafara and OnPassive made multiple and repeated materially misleading claims about the potential size of the income opportunity that the OnPassive investment program represented. Paragraph 61 concerns the payment grid that Mr. Mafara shared during the September 25, 2018 webinar, as well as Mr. Mafara's claims during the webinar that the grid showed how it was possible for participants in the OnPassive investment program to receive over $2 million per month if up to 10 tiers under them were fully populated, and that $30 million per month was feasible if more than 10 rows were populated. Paragraph 62 concerns the document that Mr. Mafara authorized, asserting that a participant could have an infinite team of downstream recruits from the participant would draw commissions and earn unlimited residual income for life. and that a participant could earn thousands and even millions of dollars through the OnPassive investment program. And that whole thing of, basically an infinite team, you do the math, and there's just only, so many levels you can go, and you'll run out of people in the world. And that endless chain type thing, So that's a bit of a problem with this whole thing. And somebody mentioned this magic spillage. Yeah. And all of this was based on exactly what Insolent Violet said, fantasy and Ash math. And Michael Aim Williams math, too. Okay. Paragraph 62 concerns the document that Mr. Mufareh authorized, asserting that a participant could have an... Okay, I already read that. I'm sorry. OnPassive investment program. Okay, that's where I stopped. Paragraph 64 states that Mr. Mufareh knew or was reckless in not knowing that the representation set forth in paragraphs 59 through 63 concerning the purported income that could be earned from investing in the OnPassive program were factually unsupportable and materially misleading. Paragraph 68 states that Mr. Mufareh and OnPassive made materially false and misleading statements and omissions in addition to those material misrepresentations addressed in paragraphs 59 through 63. Counts 2 and 3 discuss Mr. Mufareh and OnPassive's conduct as alleged in paragraphs 64 and 68 and incorporate by reference paragraphs 59, 61, 62, 64, and 68. The amended complaint thus puts defendants on sufficient notice that the statements in paragraphs 59, 61, and 62 are intended to support counts 2 and 3. Technical exactness is not required. Accordingly, the court will not dismiss the amended complaint as a shotgun pleading. Okay, got to get a little sippy poo too. Counts 2 and 3. The SEC brings count 2 under 15 U.S. blah, 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 and count 3 under 15 U.S. and blah, 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 all those numbers. A defendant may be liable under, and they document like what legal entity it is, when he makes deceptive contributions to an overall fraudulent scheme. For claims under 15 U.S.C., blah, 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 the SEC must plead 1, material misrepresentations or materially misleading omissions. 2, in the offer or sale of securities. 3, made with scienter. And scienter has to do with basically kind of, you know that you're misleading. Like in legal jargon, it's like you're knowingly misleading people. That is my understanding of what that means. For claims under 15, blah, 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 the SEC must plead 1, material misrepresentations or materially misleading omissions. 2, in the offer of sale of securities. 3, made with negligence. For claims under 15, blah, 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 SEC must plead a material misrepresentation or materially misleading omission. 2, in connection with the purchase or sale of securities and made with scienter. And that's like knowingly made or knowingly misleading. Defendants contend that counts 2 and 3 fail to state claims for relief for 3 reasons. First, the SEC does not adequately allege the existence of a fraudulent scheme. Second, the misrepresentations and omissions asserted in the amended complaint are not actionable. Third, the SEC does not sufficiently plead scienter. The court disagrees on all points. With respect to the first argument, defendants assert that the SEC fails to allege conduct that would render OnPassive business inconsistent with that of a legal MLM program, and that OnPassive's proposed business model does not meet the SEC's own definition of a pyramid scheme. The SEC responds that its detailed allegations that Mr. Mafara and OnPassive offered unregistered securities in connection with an illegal pyramid scheme, repeatedly made materially false and misleading statements and omissions to potential investors, and used counterfeit review websites to pass off internally generated positive reviews of Mr. Mafara and OnPassive as objective third-party reviews, sufficiently support the existence of a fraudulent scheme. The SEC labels the OnPassive investment program a pyramid scheme because, according to the SEC, OnPassive sells investors an opportunity to make money not through the sale of a product, but rather in return for recruiting other investors who are likewise incentivized to recruit others in an unending and unsustainable chain of recruitment. Endless chain. The SEC argues that the amended complaint specifically describes the nature of the illegal pyramid scheme, including the components of the illegal business arrangement and how it was promoted to potential investors. Construed in the light most favorable to the SEC, the amended complaint alleges a fraudulent scheme, explaining that the operation of a pyramid scheme constitutes fraud in the securities context because such a scheme is inherently fraudulent. Further, the alleged scheme is pleaded with the requisite particularity. Most of the amended complaint is devoted to describing the alleged scheme. The amended complaint alleges how Mr. Mafara started the program, how the program changed over time, how the program worked, the strategies Mr. Mafara and OnPassive used, and statements they made to investors in furtherance of the program, the counterfeit review websites they created, the special terms they used like back office and founders, the amount of money that investors could purportedly receive through the program, and the dates on which Mr. Mafara and OnPassive engaged in misconduct. The amended complaint frequently answers the who, what, when, where, and how questions concerning the alleged scheme. Accordingly, the court will not dismiss counts 2 and 3 based on defendants' first argument. With respect to their second argument, defendants contend that the statements about OnPassive legality, the timing of the product launch, and potential income opportunities are not actionable. The statements about OnPassive's legality, defendants argue, are opinions requiring the SEC to allege that Mr. Mafara did not believe in OnPassive's legality, that he supported the opinions with untrue facts, or that his omission of facts made the opinions misleading. According to the defendants, the SEC does not plead what it must in this regard. Defendants further maintain that the statement, "We will not be shut down by a government, they will use our products," is actionable puffery. As to the statements about the timing of the product launch, defendants assert that each statement is either to launch products on a specific date or an opinion the SEC fails to allege Mr. Mafara did not genuinely believe. Defendants contend that the statements about potential income opportunities are puffery and that disclaimers included with the all monthly residuals for life payment grid and the February 2020 marketing message undermine the allegation of falsity or materiality. The SEC responds that the challenge statements are actionable. The statements about OnPassive's legality, the SEC maintains, are not opinions but statements of fact. In support, the SEC states defendants use counterfeit websites to ascribe statements of legality to seemingly objective third parties not only indicates defendant scienter as to falsity of those statements, but also reflects defendants' belief that such statements had objective factual value to investors. Even if the statements are opinions, the SEC claims material omissions regarding Mr. Mafara's and OnPassive contributions to the counterfeit sites make the statements published to those sites misleading to a reasonable investor. The SEC contends that the statements about the timing of the product launch are statements of fact that were false when made because OnPassive lacked the personnel to develop the applications along the projected timelines. And even if they are opinions, they did not fairly align with the information in Mr. Mafara's possession when he made them and thus provide the foundation for liability under the securities laws. The SEC argues that the statements about potential income opportunities should not be dismissed as puffery at the pleading stage because the statements were objectively measurable. The payment grid specified the potential incomes and timeframes for investors. And the February 2020 marketing message classified income figures as realistic, conservative, and worst case. And the statements were repeated to reassure investors. The SEC further asserts that the disclaimers included with the statements do not defeat liability. Oh my gosh, more than puffery than kissing marshmallows. Oh my gosh, just that whole kissing marshmallows thing. The statements that OnPassive was fully legal and compliant worldwide are likely statements of fact, not opinions, finding that a reasonable investor could interpret as fact the statement. We are currently in compliance with existing legal and regulatory requirements. The plaintiff's statements regarding the legality of the defendant's products are not mere opinions, but rather discernible statements of fact. However, even if the statements are opinions, every statement of opinion explicitly affirms one fact, that the speaker actually holds the stated belief. A statement about legal compliance would falsely describe the speaker's mental state if he actually thought his company was breaking the law, and thus the statement would subject the speaker to liability, assuming the misrepresentation were made. As discussed more fully below in connection with defendant's third argument, the amended complaint sufficiently pleads scienter. For example, the amended complaint alleges that Mr. Mafara and OnPassive knew that they were operating an unlawful pyramid scheme. Guys, I am going to see if I can get Doug to come on and answer any questions. So underneath this stream, if you have questions for Doug, who is an attorney, put them there so that I can, give those all to him so he knows what you guys are going to be asking, if that makes sense. So you have questions, just drop them there, after the stream ends or while I'm streaming, whatever is, good for you. You picture Oz just being like, what the fuck is this buggery? Yeah, pretty much. Okay, for example, the amended complaint alleges that Mr. Mafara and OnPassive knew they were operating an unlawful pyramid scheme. It also alleges that they knew that the statements about the timing of the product launch were false because they knew when the statements were made that the product could not launch within the time frame specified in the statements. Therefore, the statements about OnPassive's legality and the timing of the product launch are actionable even if they are opinions. Moreover, a defendant can be held liable for opinions that do not fairly align with the information in the defendant's possession at the time the statements are made. Given the well-pleaded facts in the amended complaint, Mr. Mafara possessed significant information as OnPassive's CEO, including information about the counterfeit sites that ran counter to his statements about the investment program. The court agrees with the SEC that the failure to disclose OnPassive's involvement in those sites amounted to a material omission. An opinion is also actionable if the statement omits material facts that conflict with what the reasonable investor would take from the statement itself. Regarding puffery, when considering a motion to dismiss a securities fraud action in court, should not be granted the motion unless the alleged misrepresentations, puffery or otherwise, are so obviously unimportant to a reasonable investor that reasonable minds could not differ on the question of their importance. None of the challenge statements are unimportant enough to a reasonable investor to justify their dismissal as puffery at the pleading stage. Further, the statements in the payment grid on February 2020 at the pleading stage. Further, the statements in the payment grid. Oh, wait. Where did I go? Did I go too far up? Sorry. What page was I on? A statement about the legal. Something about puffery. Okay, read through this. Sorry, guys. Right, Ash should plead the fifth. I don't think he can. Can he? I guess he can say, I'm not going to speak. Okay, I think I read that. Did I read through all of this? I think I did. I bumped something. Sorry, guys. Puffery just rolls off the tongue. Hey, Sherry, how are you? Oh, wait, nope, I didn't because I'm seeing something down there. So, well, I'm just going to pick up here because I don't know where I was at. Do you know what page I was on? Anyone? Because I do not know what page I was on. Wait, I just saw puffery. They are not puffery. Okay, I think I'm going to start here. In addition to the defendant's use of disclaimers does not render the challenge statements inactionable. We could rewind. Yeah, rewind for me and find out. And tell me where it is. Page 24. Thank you. Thank you, guys. Thank you. Okay. Okay, I'm going to start here. How's that sound? All right. However, if the statements are opinions, every statement of opinion explicitly affirms one fact, that the speaker actually holds the statement belief. A statement about legal compliance would falsely describe the speaker's mental state if he actually thought his company was breaking the law, and thus the statement would subject the speaker to liability. As discussed more fully below in the connection with defendant's third argument, the amended complaint sufficiently pleads scienter. For example, the amended complaint alleges that Mr. Mafara and OnPassive knew they were operating an unlawful pyramid scheme. And to get a sip. It also alleges that they knew the statements about the timing of the product launch were false because they knew when the statements were made, the product could not launch within the time frame specified in the statements. Therefore, the statements about OnPassive's legality and timing of the product launch are actionable even if they are opinions. Moreover, a defendant can be held liable for opinions that do not fairly align with the information in the defendant's possession at the time statements are made. Given the well-pleaded facts in the amended complaint, Mr. Mafara possessed significant information as OnPassive CEO, including information about the counterfeit sites that ran counter to his statements about the investment program. The court agrees with the SEC that the failure to disclose OnPassive's involvement in those sites amounted to a material omission. An opinion is also actionable if the statement omits material facts that conflict with what a reasonable investor would take from the statement itself. Regarding puffery, when considering a motion to dismiss a securities fraud action, a court should not grant the motion unless the alleged misrepresentations, puffery or otherwise, are so obviously unimportant to a reasonable investor that reasonable minds could not differ on the question of their importance. None of the challenge statements are unimportant enough to a reasonable investor to justify their dismissal as puffery at the pleading stage. Further statements in the payment grid and 2020 marketing message are measurable, suggesting that they are not puffery. In addition, defendants' use of disclaimers does not render the challenge statements inactionable. Concluding that the net impression that affiliates could reasonably expect to earn substantial, if not life-changing amounts of money was unaffected by the defendant's use of purported disclaimers, internal quotations omitted. Given the allegations that the defendants knowingly omitted material information, general disclaimers are not enough to save them from the potential liability at this stage of the proceedings. With respect to the third argument, defendants maintain that the amended complaint contains insufficient factual support for its allegations that Mr. Mafara knew or was reckless in not knowing that the OnPassive investment program was fraudulent. Defendants assert that the amended complaint describes neither a document suggesting Mr. Mafara's knowledge or recklessness concerning the program, nor a witness showing the falsity of Mr. Mafara's statements. Defendants further contend that the amended complaint lacks support to show that Mr. Mafara had motive to commit fraud because his reason for spending the funds' personal use amounts to nothing more than an executive taking a salary for his efforts and is thus insufficient to plead scienter. In response to the SEC argues that the claims raised under blah, 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 blah do not require scienter. Regarding the remaining claims in counts 2 and 3, the SEC asserts that the amended complaint demonstrates knowing misconduct or, at a minimum, severe recklessness. The amended complaint does so according to the SEC through its allegations that Mr. Mafara and OnPassive made false statements about the timing of the product launch when they knew facts inconsistent with that timing, made false statements about the magnitude of unrealistic potential investment returns and the legality of the business organization, and created counterfeit review websites to publish fake reviews of OnPassive. The claims in counts 2 brought under blah, blah, blah do not require scienter. These claims will thus not be dismissed based on defendant's third argument. Although the other claims in counts 2 and 3 require scienter, they will not be dismissed because scienter is adequately alleged. Scienter may be established by knowing or by showing a knowing misconduct or severe recklessness. Proof of recklessness requires a showing that the defendant's conduct was an extreme departure of the standards of ordinary care, which presents a danger of misleading buyers or sellers that is either known to the defendant or is so obvious that the actor must have been aware of it. Scienter can be established through circumstantial or direct evidence. The scienter of a business entity is established by showing that the entity's officers or directors acted with scienter. Because the individual defendant controlled the LLC defendant, his scienter is imputed to it. The SEC may allege scienter generally. The amended complaint generally claims that Mr. Mafara knew or was reckless in not knowing that the operation of the OnPassive investment program, the creation of counterfeit websites, and the material misrepresentations and omissions collectively constituted a scheme to defraud and operated or would operate as a fraud or deceit on investors. The amended complaint also claims that Mr. Mafara's scienter may be imputed to OnPassive because as the company's CEO and co-owner, he exercised ultimate authority over all its operations and statements. To support these claims, the amended complaint alleges that Mr. Mafara and OnPassive knowingly and recklessly made repeated materially false and misleading statements and omissions concerning the potential income to be earned and the soundness and legality of the company's operations. According to the amended complaint, Mr. Mafara and OnPassive falsely advertised outlandish potential passive or residual returns to investors that could last for life, as when Mr. Mafara and OnPassive shared the payment grid that purported to show, based on an unrealistic assumption, how a participant can receive up to $2,032,614 per month for life. The amended complaint further states that instead of using investor funds to develop OnPassive's purported suite of applications, Mr. Mafara used them to further investment program and to pay his and his wife's personal expenses, including online retail purchases, upscale dining, television subscriptions, groceries, salon and spa trips, and purchases of stocks. These allegations support scienter. The defendant's extremely reckless statements about rates of return, levels of risk, and regulatory approval status demonstrate a high level of scienter. A finding of scienter is further supported by the fact that the individual defendant used investor funds for personal expenses. The amended complaint also alleges that Mr. Mafara and OnPassive made material misstatements regarding the feasibility and timing of the product launch while knowing or being reckless in not knowing that they lacked a factual basis for making the statements. The amended complaint states that Mr. Mafara knew or was reckless in not knowing at the time of each misstatement not only that development of applications had not yet started, let alone progressed, to the point that the product launch could occur within the time frame specified, but also that OnPassive lacked the capacity to develop the applications in those timeframes. Further, the amended complaint describes how Mr. Mafara and OnPassive reacted to negative reviews on websites by creating counterfeit sites, mimicking the names and appearances of those websites to decrease the website's positions in search results, how Mr. Mafara and OnPassive used a domain proxy to conceal their involvement with the counterfeit sites, and how Mr. Mafara and OnPassive concealed their control over the counterfeit sites and falsely presented the counterfeit sites as relying on objective third-party data to post fake, internally generated positive reviews of themselves through the counterfeit sites. These allegations also support scienter. The defendant engages in knowing misconduct when he creates documents he knows are false. The amended complaint sufficiently alleges Mr. Mafara's and OnPassive scienter. According to the claims in counts 2 and 3 that require scienter, will not be dismissed based on defendant's third argument. Because counts 2 and 3 sufficiently plead the existence of a fraudulent scheme, actionable misrepresentations, and omissions, and scienter, the counts will not be dismissed for failure to state a claim. Count 5. In count 5, the SEC sues Mrs. Mafara as a relief defendant under the equitable theory of unjust enrichment. The Securities Exchange Act of 1934 authorizes the court to grant any equitable relief that may be appropriate or necessary for the benefit of investors in an action brought by the SEC under the securities laws. The court may order equitable relief against a relief defendant where she, 1, has received ill-gotten funds, and 2, does not have a legitimate claim to those funds. A claim of ownership is not legitimate where, for example, the relief defendant holds the funds in trust for the primary violator. The ownership claim is a sham, or the relief defendant acted as a mere conduit of proceeds from the underlying statutory violation. In contrast, a relief defendant has presumptive title to compensation that she receives in return for services rendered. Defendants contend that count 5 does not state a claim for unjust enrichment against Mrs. Mafara because it does not plead facts to support its conclusory allegation that she does not have a legitimate claim to the funds that she received as a co-founder and co-owner of OnPassive. There are no allegations. Defendants argue that Mrs. Mafara received anything other than routine compensation to a founder or a dividend to an owner. The SEC responds that Count 5 adequately alleges that Mrs. Mafara had no legitimate claim to the funds she received, mainly because she allegedly gave no consideration in exchange for the funds. The amended complaint does not allege that Mrs. Mafara received compensation as a co-founder and co-owner of OnPassive, or that she rendered any services warranting compensation. Instead, it alleges that she gave no consideration for the funds that she received. Moreover, it alleges that Mr. Mafara, as OnPassive CEO, wholly controlled all of the company's operations and had ultimate authority over its activities, including all alleged securities violations. The amended complaint focuses on Mr. Mafara's actions on OnPassive's behalf, using the word Mafara to refer to Mr. Mafara and the word defendants to refer to Mr. Mafara and OnPassive. In contrast, the amended complaint refers to Mrs. Mafara by her full name and uses the term relief defendant to describe her. The amended complaint recounts numerous actions that Mr. Mafara and OnPassive allegedly undertook. But with respect to Mrs. Mafara's actions, it states only that she received investor funds from her husband, exercised authority over accounts that contained the funds, converted some of the funds to cryptocurrency, and used funds for personal expenses, including online retail purchases, upscale dining, television subscriptions, groceries, salon and spa visits, and the purchase of stocks. Although the amended complaint also states that in July 2018, Mr. and Mrs. Mafara were the only two persons involved with any aspect of OnPassive's operations, it does so while alleging that neither Mr. nor Mrs. Mafara had any expertise to develop a suite of computer applications using AI. The point of this statement is not that Mrs. Mafara was involved to a significant extent in OnPassive's operations, but that no one was developing OnPassive suites in July 2018. Construed in the light most favorable to the SEC, the statement indicates that Mrs. Mafara was not performing work for OnPassive because she allegedly lacked the expertise to develop the suite. Given the well-supported allegations that Mr. Mafara acted as OnPassive CEO and Mrs. Mafara merely received funds from her husband and used them for personal expenses, the amended complaint adequately pleads that Mrs. Mafara acted as a mere conduit of proceeds from the underlying statutory violations, allegedly committed by Mr. Mafara and OnPassive. Accordingly, the court will not dismiss Count 5 for failure to state a claim. Conclusion. Accordingly, defendant's motion to dismiss is denied. Defendant shall respond to the amended complaint in accordance with the Federal Rule of Civil Procedure. Ordered in Orlando, Florida on August 27th, which is today, of 2024. And there you have it. Try as they may, they cannot have this just poof, dismissed. And overall, the case will march on, even though it is moving at a incredibly slow pace. We will march on, and they can, continue to have a meeting in terms of the mediation. And if there is no agreement, then it will go to trial. But they're still, right now in the mediation phase. But the ability to dismiss the case, the judge has said, forget about it. So it'll be interesting to see, does Ash even address any of this? Or is this going to be also, is this a fake document that the court put out? No, it's not. It's an actual document that, you can find. This is what the judge has said, is that try as you may, you can't dismiss this case. So there you go. So anyway, that is what I wanted to share with you guys today, since this just happened, so that you would be aware that the case marches on and the migration, the fake migration continues. You know, right? The case is alive and well. Yep, it has not been put to bed, not at all, not even. Just, I mean, Ash likes to claim that he's somehow that he's won, and we can clearly point to, no, you haven't. You tried to have it dismissed, and that shit didn't work, Mr. Mafara. That shit didn't work. There you have it, my friends. Anyway, I am going to get down on the go-go because my back is really hurting since I have not taken any pain pills or anything. Well, it's not a pain pill, pain medication. It's a film thing that dissolves on my tongue. And I don't have my spinal stimulator on for the reset and everything. But I wanted to make sure that you guys were all aware of what has happened so far. And, you know, Big Marty and his companion, Chris, they're going to deny all of this. They'll all just flat out deny it. That's the thing. They will go into the world of denial. But it's just very simple. This is the judge's, ruling. It's not fake. It's the judge's ruling. So like I said, I'm going to take off. I want to say thank you very much to everybody who, showed up. Thank you to my mods. I appreciate you. Thank you to everyone who showed up in the chat. I appreciate you too. And remember, if you have questions for Doug, please put them in the comments underneath this video, this live stream, whatever the heck you want to call it. And I will see if he can come on sometime and address any of that. If you guys, have questions about what has happened so far, so that a professional can address them much better than, I don't want to take a stab at it. I'm not an attorney. I have not been trained in it. And so I could not do it justice. And I'm not going to even pretend like I can. Anyway, thank you all for being here. I appreciate you. And don't forget, you're beautiful and I love you. Until next time, have a good one, everyone. Good night, everybody. And thanks for being here. Mwah.